Hello, everybody. Today's May 15th, 2020, and I'm here with Reyes, an attorney at the firm. And we were going to cover a few of the best practices. We're getting a lot of questions about how to bring employees back into the workplace, as the state is reopening. California is reopening and various counties are reopening. So, here's our best overview of what the law, how it exists, and the best practices as of May 15th here. Things are subject to change, obviously. They're changing quickly, but Rick was going to run through some of these best practices. And with that, Rick, I'll let you dive into some of the do's and don'ts.
Yeah, thank you, Anthony. So like Anthony mentioned, we've been having a lot of questions revolving around this issue, what to do when bringing back either laid off employees or furlough employees. So we will discuss some of the things that companies should be doing and some of the things that you shouldn't be doing when rehiring or bringing employees back to work. Now, before I dive into the specifics, there are some points that employers should consider during this process. First, who exactly are you planning on bringing back? Is it going to be all of your employees, only some of your employees? Your answer may implicate several issues from a legal standpoint, specifically if your company is only rehiring a percentage of your workforce. Now, if you already know how many employees you're rehiring, will you be offering higher or lower salaries to some of them? Remember, you have to satisfy the salary threshold for an individual to be classified as an exempt employee. So you have to bear that in mind in case that you are either lowering your employees' salaries, or will you be providing higher pay incentive so that employers want to come back to work. And of course, it's always important to remember the California Employment Law 101 issues, such as expense reimbursement, meal and rest breaks, proper recording of hours worked, overtime, all of those issues. Third, were the individuals you're planning on bringing back laid up or furloughed? This has implications with respect to new hire paperwork that I'll be discussing shortly. Lastly, and if this applies to your company, of course, will certain employees be working remotely or teleworking? There are some issues that you also have to consider if that's the case. Now, jumping to the fun stuff, the do's and the don'ts. Let's start with the things that you should be doing. Your rehiring criteria. One of the most important things that you have to do is develop and document a legitimate and objective rehiring plan and/or criteria. On what basis will you be deciding who is coming back to work? Is it going to be based on seniority, past performance, on operational and business needs? This is something you have to give serious thought. Another thing that you should be doing is review your job descriptions. This is particularly important for those companies who will only be bringing back a percentage of their workforce. Ensure that your job descriptions are current. For example, if you will be requiring further job duties, such as cleaning and disinfecting now, given the pandemic, make sure that this is part of your job description that is included. Continue with your regular application process. For all laid off employees, have them complete an application for employment and undergo your company's application process. Now, it is up to you whether you want to relax some of your company's application procedures, such as not requiring them to undergo either a drug or alcohol test or background checks, unless this is required by law, of course. As you've heard us say before, and we will continue saying it, document everything, specifically employment or recall offer letters. Reducing these letters in writing should already be a company procedure. And this is particularly important when an employee rejects the offer, as it may have implications for the PPP loan or for unemployment purposes. Now, as I mentioned before, complete new hire paperwork. You have to treat laid off employees as new hires and provide them with all required paperwork as you would for any new employee. Now, there is a slight wrinkle for Form I-9, which has to be completed if the employee completed his or her I-9 form over 3 years ago. If it's been less than 3 years ago, then you may not need to complete the full verification form again. Now, another thing that you should be doing is provide reasonable accommodation. This is important in both the application process and once the employee is hired. If an employee requests an accommodation, you should engage in the interactive process. And unless the accommodation poses an undue hardship on your company, you should provide it accordingly. Now, another thing that you should be doing right now is train new hires and supervisors. Although employees are going back to work, the circumstances have changed. And as such, it is crucial that employees and supervisors be trained on health and safety issues and on any new protocols or policies that your company has developed in responding to and addressing COVID-19 concerns and issues. Also, this is something that you have to remember. Remind everyone at your company about the company's anti-harassment, discrimination, and retaliation policies, as those remain well in effect during this pandemic. Make sure that you post all the legally required workplace posters, such as the Families First Coronavirus Response Act or the California Supplemental Paid Sick Leave posters if you're a covered employer. Also, this might be a good time to review and ensure that you have the most up-to-date posters. Now, something else and very important here is paid sick leave. If your company did not cash out an employee's unused and accrued paid sick leave under regular California paid sick leave, and an employee is being rehired within 1 year of his or her termination, you must reinstate such paid sick leave. So don't get caught off guard and be on top of that. Now, turning to the things that the company should not be doing. Do not use a discriminatory rehiring criteria. Do not use any protected category as the basis for that criteria. This could be either age, disability, sex or gender, religion, amongst others. Now, I want to point out that the EEOC's guidance provides that the fact that the CDC has identified those who are 65 years or older, or if the employee is pregnant, they are being considered a greater risk, but that doesn't in and of itself warrant automatic disqualification from employment. So be careful with that. Also, do not misclassify employees. Remember to properly classify them as either exempt or non-exempt, and review what the requirements are for each. Also, remember that AB 5 went into effect this year, which sets forth a more stringent test for classifying an individual as an independent contractor rather than an employee. So keep an eye out on that as well. Okay, now that you have your hiring under control, everything seems to be working out well. But then one day, one of your employees complains about personal protective equipment. What to do? First, you have to remember that California employers are required to conduct assessments to determine if a hazard is present in the workplace that would require the use of PPE. If you do identify that COVID-19 is a workplace hazard, then you must provide your employees with the appropriate PPE. Now, what are some of the situations in which an employee may complain about PPE? Consider some of the following. Is it going to be because you don't have enough PPE to provide to your employees? Is it because the PPE is ineffective? Or is it because the PPE might interfere with the employee's ability to safely perform his or her job duties? Or is it simply because the employee is not comfortable wearing the PPE? These are only some of the few issues that might come up. So what should employers do? The next discussion incorporates both preventive and reactive suggestions. In other words, things employers should do to avoid a complaint from ever coming up, and things that your company should do if an employee does complain. The first thing, maintain and provide the right type of PPE. Now, this will vary from business to business and from jurisdiction to jurisdiction. So be attentive and ensure that you're in fact providing your employees with proper PPE. For example, think of thoroughly cleaning and disinfecting reusable PPE. And if this is not feasible, then consider using disposable PPE. Also, develop policies and procedure with respect to the proper use and disposal of PPE. This is very, very important. Develop a complaint procedure. Designate a point person. That way, these issues are centralized in a single individual or group of individuals. Something that we found that is very effective is to implement an open door policy. The more welcome employees feel, the less likely is that the situation scale into something worse. Now, once a complaint is made by an employee, you have to assess and address it seriously and promptly. Gather all documents and the relevant information, the who, the what, the when, and the where. And if it's necessary, perhaps conduct interviews. Work directly with the employee in trying to find a solution to the problem. Opening these lines of communication is key to a successful dealing with the problem. So what should employers not do in dealing with employees' complaints? Do not ignore or be dismissive of employees' complaints. The better receptive the company is, the less likely that the issue will escalate any further, as I previously mentioned, and the less likely is for an employee to take any further legal action. And this is very, very important. Do not harass, discriminate, or retaliate against an employee for raising a concern. Employers must remember that it is unlawful to retaliate against workers because they report unsafe working conditions. So employers must refrain from taking any kind of adverse action, which could be termination, demotion, or reducing the employee's wages just because he or she complained. And lastly, do not remain static. Things are changing on a daily basis, so continue to evaluate and determine which practices and procedures are the most effective in addressing these issues. As things continue to change, your business must remain flexible and adapt to new circumstances and developments. And as always, continue to comply with federal, state, and local laws and guidelines.
Great, thanks for that overview, Rick, and really important information. And on this final slide, we've got some information on how to stay current. We're updating this almost daily for updates on the federal, state, and local laws on these issues as employers are bringing their workforce back into the workplace. Thanks, Rick.
Yeah, of course. Thank you.